I'm wondering if anyone on the panel or maybe anyone in the audience knows, does the IRS have a policy what they're going to do with people if they have now discovered they had a foreign bank account and they're under audit?
I can tell you that currently I have a number of those cases in the office in which people wanted to participate in the voluntary disclosure program, didn't know that they had been selected for audit. One case I'm thinking in particular, they had a fine New York firm representing them. They sent in the precursor for preliminary approval, and the position of the IRS was, even though the audit has not commenced and even though you did not know that you were selected for audit, it's too late, we are not going to accept you for the voluntary disclosure program. That means that the service is maintaining its right to conduct the audit and assert all penalties available to it under the code, but more importantly is keeping its option open as to whether it will ultimately refer the case for CID review and criminal prosecution. Another matter that we have in the office, someone, again another firm, but this one out of Virginia, they sent in the voluntary disclosure program from the 2009 program, and unfortunately those first 300 to 400 names that were turned over by UBS, they were in there. And again, they took, despite the fact that the client did not know that they were in the 300 to 400 names and had filed it, the IRS took the position that the voluntary disclosure was untimely and maintained its position.
My question is for people who were not rejected from the program, did nothing, are now under audit. Does the IRS know what they're going to do? Are they going to refer these people to criminal? Are they being screened by CI first before they go to exam? Do they know what penalties they're going to impose? Or is it just an ad hoc basis?
You're talking about quiet filings?
No.
They got audited?
People did nothing. They did nothing. They're now being audited, and they know they have a foreign bank account.
Oh, I can tell you very clearly on that. The IRS position is that they've lost the lottery and that all penalties are available to the IRS in those cases.
Are they imposing them?
Well, I know that the cases that I have right now, they are discussing imposing them, and one or two of them, they're discussing imposing indictments, but the indictments have not been forthcoming. Of course, that's not a complete surprise. As you know full well, an investigation of that type takes 2 to 3 years on average. So, but they have clearly stated that they don't feel bound to make any type of accommodation just because there's a voluntary disclosure program going on, because the client did not come forward and make itself take advantage of the opportunity.
Yes.
Well, since you and I discussed this issue yesterday, and the question becomes, what do you do? Your client is being examined. The revenue agent says, I want to know about the foreign bank accounts. I know there's foreign bank accounts. And so what do you do? And that's sort of the beauty of the practice of law. It's not a science. Nobody can say that with every particular answer or non-answer that a particular result will occur. My thought is this: not everybody that has a foreign bank account that is being examined is going to be indicted, simply because they don't indict that many cases. Statistically, you just can't indict everyone. So then the question becomes, how do you handle it? There's a few ways. If you lie to the revenue agent, that's the lie that may make for the obstruction and the overt act or the continuing crime. So to begin with, what I would tell a client in that situation would be, one, I can't tell you exactly what's going to happen. I don't have a crystal ball. Two, you can't lie to the revenue agent, because if you say to the revenue agent, I have no foreign bank accounts, you answer the question. I have no foreign bank accounts. The revenue agent has a copy of your foreign bank account with your signature on it from Liechtenstein. You've now given the revenue agent the excuse for the revenue agent to refer the case to criminal. So what do you do in that situation? Oftentimes, what we as practitioners can best do is protect our clients from themselves, or sometimes from their own stupidity or arrogance. So in that situation, I often thought that you do a dance. I'm not a particularly good dancer, but what you say to the revenue agent is, look, my client's not available to speak to you. My client will not speak to you. If you believe that there's a foreign bank account, we're not going to address the issue. We're not going to confirm or deny anything. But if you think there's a foreign bank account and you want to write up the examination report, we may agree to it. We may simply agree to it. The theory being that money penalty is better than a criminal prison penalty. And then that revenue agent is going to have to come to a decision what to do. If they refer it to criminal, to CI, what they have is that your client has a foreign bank account. They don't have further information that might be certain indicia of criminality other than the existence of a foreign bank account. They need to prove, in a criminal case, they need to prove willfulness. In other words, that you had that particular individual had the specific intent to commit a crime, which is a high burden. And even though they may have had the specific intent to commit a crime, the IRS tends to be conservative in prosecuting people, wanting to prosecute people that they believe they can obtain a conviction. So in that situation, what they may simply do is, like you were saying, David, they may just they'll throw the book at him civilly, but you've saved your client from the criminal result. You can always then litigate at a later time. You can litigate issues up the chain at a higher level of the IRS and appeals. Maybe try to get the penalties down, and those are decisions you can make later. But unfortunately, I don't.
No, I wanted to chime in on and agree with something you said. One thing that I feel very strongly about, and something that Dennis mentioned, is you have to make sure that the client understands that lying is never an option, that it's always best to refuse to answer, but not good at all to try to talk your way out of it, and worse, to try to lie your way out of it. Under what Dennis had just described, you would see that if the agent chose to write it up, he really doesn't have a lot of additional facts. And if he chose to refer it, he really doesn't have any additional facts either. Either way, that is advantageous to the taxpayer, because at that point, that taxpayer is going to be referred in my door for the defense, and his biggest advantage is the element of surprise. You don't want to, and I know there are people in this room, you don't want to provide the evidence that is the death knell on the decision whether to indict your client or not. Cases are built on evidence, not on whether or not your client is friendly to the agent. And if your client is sitting there answering questions and filling in all of the contingencies that the agent had, he's increasing his chances of getting an indictment, not decreasing them. And he is also increasing his chances of losing at trial if a trial comes about. So, clients really have a problem with that. They believe that if you're nice to the agent and the agent asks them a few innocuous questions, which all agents are trained to start out the conversations with, that they'll be able to make this go away. It never works. What happens is that they aggravate the situation, because once they start asking questions, then when the hard questions come, they can't stop, and now they're either forced to confess or lie, and both of those options are terrible.
David,